discussing legislative assemblies. Again, that provision that was there with respect to reservation of seats of Anglo-Indians, it has been removed also in the legislative assemblies, not just in the parliament, it has also been removed in the legislative assemblies. So no more reservation is being provided, to the members of Anglo-Indian community. One more thing that you should know here is currently the bill that we are talking about, which has removed this provision, it is the 126th Constitutional Amendment Bill. 126th Constitutional Amendment Bill. Constitutional Amendment Bill. Now, it is in the process of being ratified by the states. It is in the process of being ratified by the states. Now, yesterday itself, day before that, when we were discussing passage of bills, we did discuss Constitutional Amendment Bill, and in our discussion there, what did we see? That there are two kinds of constitutional amendment bills. Some bills which require a special majority and only a special majority of the parliament. On the other hand, there are some bills which affects the status of states or center-state relations, and there is an additional requirement of more than 50% of the states ratifying the bill. Did we discuss this or not? So right now, this particular bill, because it also concerns the state legislature, so it is in the process of being ratified by the states. Once it is ratified by more than 50% of the states, it goes to the president. The president signs the bill and it becomes the (104th) Constitutional Amendment Act. Clear? So you have written there 104th Constitutional Amendment Act. Just add there 126th Constitutional Amendment Bill. Currently it is 126th Constitutional Amendment Bill. When it will, when yesterday's class, उतने पीछे जाने की जरूरत नहीं है. Look at yesterday's class. ठीक है, आपको पता होना चाहिए what we have discussed yesterday. 103rd constitutional is with respect to reservation to 10% reservation to economically backward classes, economically weaker section. Clear? So it will become the 104th Constitutional Amendment. Now, with this, yesterday we had completed our discussion on state legislatures, and now we start with emergency provisions, legislative councils. Yes.
What is the utility of that council when Constitutional Assembly has opted for this kind of burden on these state?
See, the utility of it is whenever we talk about states and the kind of membership that is there given to the legislative councils, you can see that legislative councils, the members who are elected to legislative councils, either they are being elected by either graduates, teachers, local bodies. So it is conceived that when people who are elected to such bodies, some people are nominated, some people are being elected, it is very likely that specialists or those individuals who have some special knowledge with respect to certain ideas, they are to be elected in legislative councils. Because they are not truly the representatives of the people, they are not truly, because there is no provision for direct elections there. So they will not have the similar powers to that of legislative assemblies, because legislative assemblies are the representatives of the people. So they will not have the similar, they will not have the similar powers that the legislative assemblies have, but they will still enjoy this influence on the legislative council. Why? Because if a group of experts or a group of individuals who have some kind of special knowledge or experience, or suppose individuals from local bodies, they are electing individuals from among themselves. Suppose they elect individuals from among themselves to get representation in such a body. So an individual who has worked with local bodies, they are getting representation, so they will be able to put forward a decentralized view of the bills that are being presented. Similarly, if there are teachers or graduates that are voting, so teachers they have their own way of looking at certain things. Utility is in that manner, that there will be more and more specialization, more deliberation on the bills that are passed by the legislative assemblies. That is the utility. So and that is the reason why we don't have it everywhere. Only in those states which have the population, where the population is more, the number of seats that are there more. So if the number of people that are to be represented, they are more, so there will be more representation. This is the basic idea behind it. Let's start with emergencies. First is Article 352 of the Constitution. Article 352 of the Constitution, which deals with national emergency. Article 352 deals with national emergency. Now, what is national emergency? National emergency basically national emergency are imposed on the grounds of war, external aggression, and armed rebellion. War, external aggression, and armed rebellion. The term armed rebellion in the original constitution was written as internal disturbance. It was substituted from the constitution, and the term armed rebellion was added to the constitution by the 44th constitutional amendment. (44th constitutional amendment). And this 44th constitutional amendment, it not only amended the term internal disturbance and introduced the term armed rebellion, there were number of other changes that were made under Article 352 of the Constitution by the 44th constitutional amendment. There is a political background to this. You can see the term, the year 1978, which means it was a constitutional amendment after the national emergency was imposed. It's not to say that national emergency was not imposed before this or it was not imposed after this. National emergency has been imposed previously also during the term of war. That means whenever India has been at war with Pakistan, we have imposed, even with China, we have imposed national emergency. But for the first time in 1975, national emergency was imposed on the grounds of internal disturbance. That means the JP movement was going on. The JP movement, Jayaprakash Narayan challenged Indira Gandhi, and during this whole process, there was a court's decision. There was a case called as, there was a case in which Indira Gandhi, Allahabad High Court declared Indira Gandhi to be convicted of electoral frauds. Because she was convicted of electoral fraud, she could not anymore, she was disqualified from the, legislature. She could not anymore be the prime minister. Because if the same decision was given by the Supreme Court, it meant that she was disqualified. However, the decision was not of the Supreme Court, it was of the Allahabad High Court. And under this decision, morally, Indira Gandhi had two choices. First of all, to resign from the prime ministerial position, but she opted for the second choice, that is to impose emergency. She thought that this was something that was needed, and on the grounds of internal disturbance, because of what happened in the Allahabad High Court and because of the JP movement that was going on, she imposed national emergency. Clear? Now, if you look at current Article 352 of the Constitution, Article 352 of the Constitution says that the President will proclaim national emergency on the written recommendation . On the written recommendation of the cabinet, of the Union Cabinet, Article 352 of the Constitution further, Article 352 of the Constitution further says what? It further mentions the procedure. So, once the President has proclaimed national emergency on whatever, of these three grounds, what is the procedure that is to be followed? The procedure that is to be followed is that such a proclamation needs to be approved . Needs to be approved by both the houses. Both the houses of the parliament within 30 days. Within 30 days of the proclamation. Within 30 days of the proclamation, by a special majority. By a special majority. Article 352 further says, once approved, the national emergency continues for Once approved, national emergency continues for 6 months, and for further continuation, it has to be approved every 6 months. It has to be approved every 6 months. Clear? This is the procedure that has been mentioned under Article 352. Now, if we look at the 44th constitutional amendment, because of the 44th constitutional amendment, these were the changes that were made. First, the term internal disturbance was substituted by the term armed rebellion. Written recommendation of the Union Cabinet was added by the 44th constitutional amendment. Originally, the constitution said 2 months. It was amended and made 30 days by the 44th constitutional amendment. Previously, constitution said simple majority. Simple majority was amended and special majority was added. To be approved by, approved every 6 months. That means once it is approved, it continues for 6 months. And to be further continue it, it has to be approved every 6 months. This was also added by the 44th constitutional amendment, which means originally what did the constitution say? Originally it said the president can proclaim national emergency on the grounds of war, external aggression and armed rebellion. And once the president proclaims the national emergency, it has to be approved by both the houses by a simple majority within 2 months. Once approved, it continues for an unlimited period. To ensure that there is a proper check imposed on how national emergency is proclaimed and how it works, the 44th constitutional amendment significantly changed the Article 352 of the Constitution. First of all, the term internal disturbance was removed because this was a vague term. What could mean by, now what is the meaning of internal disturbance? It could be anything. But armed rebellion is a more objective term. That okay, if there is an armed rebellion against the state, that means use of violence. No, there is use of violence within the country to overthrow the state. If that is the case, in that case we can impose national emergency. It will be imposed by a written recommendation of the cabinet, not just by a proclamation of the president. President will proclaim national emergency, but such a proclamation will have what? It will have to have a backing of the written recommendation of the cabinet. Once the president proclaims emergency, it has to be passed or approved by both the houses of the parliament within 30 days, not 2 months, by a special majority, not simple majority. And once approved, it continues only for 6 months. For further continuation, it has to be approved again every 6 months. That means national emergency can continue for an unlimited period. It can continue for an unlimited period provided it is approved every 6 months. Clear? This is how national emergency is proclaimed. Give a subheading, right? Withdrawal of national emergency. Withdrawal of national emergency. So how can the national emergency, once it has been proclaimed, how can it be withdrawn? First, by a proclamation of the president. By a proclamation of the president. Second, if it is initially not approved within 30 days, initially not approved within 30 days by both the houses of the parliament, Third, if it is not approved before the completion of 6 months, before the completion of 6 months after the initial approval, by both the houses. Fourth, or next point, by a special sitting of the Lok Sabha, disapproving the continuance of national emergency. Obviously, we have discussed what is the process here. How can the Lok Sabha disapprove continuance of national emergency? Either to the speaker or the president. Okay, what happens then?
Within 14 days, special sitting.
A special sitting is called. Whereas if through a simple majority, if it is disapproved, then the emergency will not continue. So these are the mechanisms in which national emergency is withdrawn. Next, consequences of national emergency. Where you have written this power to disapprove of Lok Sabha, the Lok Sabha's power, again there in brackets write 44th constitutional amendment. The 44th constitutional amendment. 44th constitutional amendment. One more change that was introduced by the 44th constitutional amendment in emergency provision is that national emergency, when it is being proclaimed by the president, it can be proclaimed either for the complete territory of India, or for a part of it. That means once national emergency is proclaimed, it does not mean it automatically is extended to throughout the territory of India. This change was also added by the 44th constitutional amendment. It was also added by the 44th constitutional amendment. And an example of this was what happened during the Punjab insurgency. When Punjab was, there was insurgency going on in Punjab, in that case, national emergency was imposed only for the state of Punjab. In fact, their national emergency was in place only for this particular area, not for the whole of the country. Clear? So this is the 44th constitutional amendment. And 44th what was the consequences of 44th constitutional amendment? Now give us a heading, right? Consequences of national emergency.
This provision.
Yes, it can be handled. There is a choice. See, when I say a state, it does not mean only for the complete of the state also. It may so happen that even in the state, some districts or some place, some region is under national emergency, not all of the state. That is also a provision that can be done. Like when we talk about when we talk about the UT of J&K, there is insurgency and separatism there. So in that case, it may so happen that identifying only those region which is problems, the union government may impose emergency there. Similarly, in India, when we talk about Naxalism, so Naxalism, there are problems with Naxalism, but they are not necessarily for the whole state. So if we talk about the state of Jharkhand or the state of Chhattisgarh, they are not completely influenced by Naxalism. Only some part of it, some districts are they suffer. So it may so happen that emergency is imposed only for that particular district. So there is no need for imposing state emergency there. Impose national emergency in that region and direct the state what is to be done. What are the consequences of national emergency? Consequences of national emergency can be executive, legislative, financial. There are some executive consequences, there are some legislative consequences, and there can be some financial consequences as well. What are the executive consequences? Let's start with the executive consequences. Executive consequences of national emergency. You can write this. The power, the executive power of the union, the executive power of the union extends to giving direction to the state executive, how the functions of the state, how the executive functions of the state are to be carried out. Executive functions of the state are to be carried out. Once national emergency is imposed, it means that now the union executive can give directions to the state executive how to exercise their, that means state's executive powers. Second, legislative consequences. First, under Article 250, the Constitution, Article 250 of the Constitution provides that the Parliament gets the concurrent powers. The Parliament gets the concurrent powers to legislate on any subject mentioned in the state list. Any subject mentioned in the state list. So now don't write this. Once national emergency has been proclaimed, now under Article 250 of the Constitution, the Union Legislature, that is the Union Parliament, now can also make laws for any matter that is mentioned in the state list. For any matter that is mentioned in the state list. Clear? This is a power that it gets under Article 250. Next, within legislative consequences, the life of the Lok Sabha, or the legislative assemblies can be extended by a maximum of 1 year at a time. 1 year at a time under a law made by the Parliament. In brackets mention Article 83 and 172. Under Article 83, it is of the Lok Sabha, and 172 legislative assemblies. Clear? See, when we talk about Article 250 of the Constitution, or for that matter, when we talk about Article 83 and 173 of the Constitution, basically what happens is that as soon as the emergency is over, that means once the President has proclaimed that no more national emergency is in existence, or through any of such mechanisms that we have talked about in withdrawal of emergencies, the national emergency ceases to exist. In that case, the laws that are made by the parliament on state subject or on state list, that will be further applicable after the withdrawal of emergency, it will be further applicable for 6 months. It will be further applicable for 6 months. That means, no, maximum for 6 months it can continue. After the emergency has been withdrawn, maximum it can continue for 6 months. It may be withdrawn before that also, but depending upon the situation, it may so happen that the parliament feels that this law should further continue for a 6-month period, so it can further continue for 6 months after the withdrawal of emergency. Similarly, if the life of the Lok Sabha or the legislative assemblies have been increased by 1 year at a time, as soon as the emergency is over, the elections to the concerned legislative assembly and the Lok Sabha it is to be conducted within 6 months. Within 6 months, a new legislative assembly or a new Lok Sabha needs to be constituted. Clear? This is what is mentioned under Article 250, Article 83 and Article 172 of the Constitution. Clear? This is the legislative consequences. Next, financial consequences. See, if there is a law being made, so the law will be applicable for the state. No, it's not just for, if suppose the union legislature has made a law on state subject for a particular state, so it will be applicable for the state, not just for that particular district. It will be applicable for the state. But necessary, when the law is being made, law will so be made that if the parliament wants to extend the law only to some areas, so it can do that. Example, I'll give you an example. Have you heard about something called as Armed Forces Special Powers Act? So see, Armed Forces Special Powers Act is a law that is made by the parliament but not extended to all of the country. It is only extended to some region wherein there is some problems with respect to law and order. Clear? So when the law is being made, law will so be made that the parliament will get the authority to either extend the law to whole of the country, whole of the state, or some part of it. Similarly, if we talk about the extension, 1 year extension that is there, so 1 year extension of legislative assembly, which means it will be for all of this, no, whole of the state, not just for a particular district or a constituency. Clear? Next, financial consequences. The financial distribution of powers, between the center and the state, ceases to be in effect during the period of national emergency, and they come under the total control of the union government. In brackets mentioned Article 354 of the Constitution. So Article 354 of the Constitution says, it talks about what will happen to the distribution of finances or revenue when a national emergency is imposed, and it says that now the provisions with respect to distribution of money, distribution of financial powers, it will cease to exist. It will no more be applicable. So as soon as national emergency is declared, the financial control or the power of distribution of revenue that is there, it is completely absent. Money is not distributed, it is under the complete control of the union. So it may so happen that the union only gives that much money to the states which they feel is necessary only for day-to-day administration, and the rest of the money may be used by the union for its own purpose. Like if suppose there is a war, So to finance the war, there may be requirement of some additional finances, and in this case, the union may encroach upon the financial jurisdiction of the states and finance its war efforts through this very idea. Clear? This is financial consequences of national emergency. Can I add anything here? Or when we say national existence of emergency, national emergency, when national emergency is proclaimed, do only executive functions get affected, or legislative or financial functions get affected, or something, or constitutionally speaking, is there some other effect also on on proclaiming a national emergency? Fundamental rights, yes. Fundamental rights. Which article? Article 358 and Article 359. Article 358 and 359, which talks about suspension of fundamental rights. And it says what? Article 359 says what? Article 21. Article 20 and 21 will not be suspended. This was also added by the 44th Constitutional Amendment. This was also added by the 44th Constitutional Amendment, that there will be no suspension of Article 20 and 21, availability of Article 20 and 21. This was added by the 44th Constitutional Amendment. Clear? So I have already discussed suspension of fundamental rights, so I am not going to go into the details of this particular idea. Yes. What I have said is that the Parliament of India enjoys the concurrent jurisdiction to make laws on state subject. Such a law will be applicable for a maximum of 6 months after the emergency has been withdrawn. That means if emergency goes on for say 3 years, so 3 years plus 6 months. It's not 6 months, it is 3 years plus 6 months. So whatever the time for which national emergency has been proclaimed, plus an additional period of 6 months. Parliament has already enacted the law. That law is applicable for an additional period of 6 months. No, the law is not a permanent law. The law will not be a permanent law, and once the emergency ceases to exist, the Parliament again does not have any power to enact that law for in the state subject. Under Article 250, they do not enjoy that law, that power. It is only when emergency has been proclaimed. Clear? Clear? This is what is national emergency. This is what is national emergency. Interestingly, there is no such, if you look at constitutions around the world, that are federal countries, that are federal constitutions, there are no such provisions that are present. Where have we borrowed the emergency provisions from? Where have we borrowed emergency provisions from? From which constitution have we borrowed this? Yes? Germany. We have borrowed it from Germany. And otherwise, if you look at federal constitutions of the world, now if you look at the federal constitutions of the world, you will not find that in a country like US, there is existence of an emergency, a national emergency or something like that. In US, what exists is a martial law. But martial law is taken up not by the president but by the governor of the state. That means when it is imposed generally by the governor of the state, not by the president. And when there is breakdown of law and order, but this breakdown does not amount to the state giving up its executive and legislative or financial powers. That means even if such, obviously every country will have provisions with respect to war or external aggression or something like that. So yes, there are provisions, but the provisions that are there in India, wherein the states do not enjoy any more the executive powers, or for that matter the legislative powers, that is not the case. That is not the case. So they do not give up their executive, legislative and financial powers during the existence of such circumstance. There was only one case in which when Kennedy was the president of US, he actually used something that is similar, that is present in the Constitution of US. The president has the power in US to federalize any body. That means if any body that is belonging to the state, he has the power to federalize that body, which means now it will work under the jurisdiction of the federal government, not under the state government. So there every state has its own. Now every state that is there, they have their own paramilitary forces, unlike India. In India we have, it is the Union, Home Ministry, which has, under which paramilitary forces are working. That is not the case in US. In US, every state has their own paramilitary forces. There it is known as the National Guards. There it is known as the National Guard. And they are primarily responsible to the governor of the state, not to the president. So it is the governor of the state who directs the National Guards what is to be done. So when Kennedy was the president of US, there was a circumstance that existed wherein one of the states, it was going against the, it did not want, it was taking up like a rebellion against the United States of America. So JF Kennedy then federalized the National Guards and ordered the National Guards to maintain peace and law and order. Thereby the governor of the state was deprived of its powers, and it was now the president who enjoyed those powers. But this is very rare, as we say, more around 250 years of their constitutional history, and there is only one incident that I can quote, in which this has happened. In India, national emergency can be imposed on various grounds, that is war, external aggression as well as armed rebellion. And when it is imposed, the union government enjoys all the powers, even that is traditionally enjoyed by the state government. Now it gets centralized in the union government. Clear? Next, state emergency or president's rule. State emergency or president's rule. Now, I have previously also talked about Article 356. I have not discussed it, but I have mentioned Article 356. However, to understand Article 356 of the Constitution, or when we say the existence of state emergency, to properly understand this, we should first understand what is mentioned under Article 355, because it is Article 355 of the Constitution from where the Union actually derives this power. Article 356 is just a mechanism. It is just a mechanism. The power or the reason why the Union exercises the power to impose precedence rule or state emergency, it has been mentioned under Article 355 of the Constitution. What is Article 355? Article 355 of the Constitution gives two kinds of duties, or imposes two kinds of duties on the union government with respect to the states. What are those two duties? The first duty is that the union government has the responsibility to protect the state against any kind of internal disturbance. So when it comes to, in India, we know that though there is a body called as the state police, and the state police works under the state, it is under the jurisdiction of the state, but the primary responsibility of the state police is what? To maintain law and order. It does not have combative role. It is only to maintain law and order. That means the state police, the state police is not responsible for, you will not find the state police being responsible for taking up operations against, and any of such such specialized groups, like, if we talk about terrorism. So you will not find the state police primarily being involved. Yes, they are involved. It's not to say that they are completely excluded from this. They are also involved. Why? Because obviously they have the duty to maintain law and order. So they are also involved. But this duty that is there, it is the duty of the union government to ensure that the states do not face any kind of internal disturbance. And that is the reason why you will find there are paramilitary forces, and these paramilitary forces are they are stationed, they are deployed in various states. So today, if you see the problems of Naxalism, to handle the problems of Naxalism, we have an organization called as the CRPF, and the CRPF is deployed. Similarly, you will find that there are some states which have some borders that are there of the state. These borders are also they are also controlled and maintained by some paramilitary forces, BSF, ITBP, etc., etc. So under Article 355 of the Constitution, it is the duty of the union to ensure or to protect the state from any kind of internal disturbance. Article 355 of the Constitution also imposes another duty. The second duty is that it is the duty of the union to ensure that the government or the administration of the state is run in accordance to the constitutional machinery. In accordance to the constitutional machinery. So Article 355 explicitly mentions that it is the duty of the union to ensure that the government and administration of the state, it is taken up through what? It is taken up through or in accordance to the Constitution. States or the administration of the states cannot violate the provisions of the Constitution. It has been mentioned under Article 355 of the Constitution. Why? Because it is the duty of the union or the center. Now, if you look at Article 356 of the Constitution, what does it say? Article 356 of the Constitution just says, it mentions the mechanism through which the central government actually does this. It mentions the mechanism through which the central government actually does this. What is the mechanism that is mentioned? The mechanism says, on the receipt of the report of the governor or otherwise, if the president is satisfied that the government and administration of the state cannot run in accordance to constitutional machinery, the president will assume the executive functions of the state. The president will assume the executive functions of the state. So who has the duty? The union under Article 355. What is Article 356? It mentions the mechanism through which the union exercises this power. How will it do that? There will be a report that is submitted by the governor, and if the president sees the report and finds that in this report the governor says that the administration of the state cannot run in accordance to the constitutional machinery, and not just on the receipt of this report, even otherwise, even in other reasons, because of other reasons, if the president feels that the executive functions of the state cannot run in accordance to the constitutional machinery, the president will assume the executive powers of the state. What is meant by this assumption of executive powers? It means the president has imposed precedence rule or state emergency. Because the president assumes the executive functions of the state, the council of ministers are dismissed. Because council of ministers are performing the same idea. And such powers, once assumed by the president either exercises these powers directly or through any other individual appointed by the president. So generally what happens? It is the office of the governor. It is through the office of the governor that the president exercises such powers. Now, we were talking about the office of the governor. During this particular office, I introduced you to a term called as combative federalism. And I said the two principal mechanisms was Article 356 of the Constitution and the office of the governor. Now, based on our previous discussion, you know why the office of the governor can be used for combative federalism. Now, when we look at Article 356, what provisions do Article 356 makes to ensure that there is that combative federalism? To understand this, we also have to look into what Article 255, Article 256, 257 and Article 365 of the Constitution. Article 256 and Article 257 of the Constitution says that the Union Executive has the power to give directions to the state. Article 256 of the Constitution explicitly mentions what are how the Union Executive and the State Executive are to exercise their executive functions. And what does Article 256 say? Article 256 specifically mentions that the State Executive is to exercise its the executive functions in a manner so that it does not contradict the executive functions of the Union. It cannot. The State Council of Ministers cannot go against any direction that is given by the Union Executive. Article 257 of the Constitution further says the Union government can give directions to the state with respect to maintenance of lines of communication, with respect to maintenance of railway property, with respect to maintenance of or promotion of Hindi language, also with respect to maintenance of some property, some important property of the which is of national importance or for state importance. In these cases, under Article 357 of the Constitution, the Union government can give directions to the state. Clear? Clear? Now see what Article 365 says. Article 365 of the Constitution says that such directions that are given by the Union, if not followed by the state, can be a valid ground to impose state emergency. It can be a valid ground to impose state emergency. That means Article 365 of the Constitution also talks about Article 365 of the Constitution also talks about the power of the Union to give directions to the state. It also talks about this, but it also says that if such directions are not followed by the state, it amounts to breakdown of constitutional machinery. So when you look at Article 356 of the Constitution, or when we talk about state emergency, you have to start with Article 355. Article 355 empowers the Union to do what? It empowers the Union, Article 355 empowers the Union that it is your duty to ensure that the government of the state is run in accordance to constitutional machinery, which means whatever the Constitution provides for, the provisions, it cannot be violated. Now what does Article 256 say? Article 256 of the Constitution says that the executive powers that are enjoyed by the state, it should be enjoyed in a manner that it does not in any way contradict the executive powers of the Union or the center. Article 357 further says that the executive power or the executive authority of the Union extends to giving directions to the state in these conditions, whether it is maintenance of railway lines, maintenance of communication, maintenance of some kind of protection of certain kind of property. All these things are mentioned under Article 257. Article 365, what does it say? Article 365 says that in any case, if such directions are given to the state by the union executive, not followed by the state executive, it will amount to breakdown of constitutional machinery. And what does Article 356 say? It says that if the president feels that there is breakdown of constitutional machinery, he can assume the powers of the state executive. So whenever we read President's Rule, generally we tend to stop at Article 356 of the Constitution. But what you need to see is what does it starts. Kahani shuru hoti hai Article 355 se. It's not Article 356. It starts with Article 355. And it extends beyond Article 356 because you will always have to see it in the context of what is the executive powers of the union. And executive powers of the union under the Constitution extends to giving directions of the state. Article 365 says if such directions are not complied by the states, it will be considered that there is a breakdown of constitutional machinery. And Article 356 says what will be the consequence of it. Agar breakdown hoga, president will assume the powers of the union executive. Now see, Mamata Banerjee says we do not have the responsibility to protect railway property. Fine. What she should say is that what we should do is we should petition her. Please say this in the legislative assembly of the state. कहीं और नहीं बोलो, legislative assembly में बोल के दिखाओ. अगर आपने legislative assembly में ये कहा, that is a valid ground for imposing national state emergency in the state. It is a valid ground because Article 357 explicitly mentions it is the responsibility of the state, or the state can be given directions to this. For this, the state can be given directions by the union. The states can be given directions by the union. तो बंगाल में स्टेट इमरजेंसी बस इस वजह से नहीं लगा अभी तक क्योंकि बाकी जगह प्रॉब्लम चल रही है, नहीं तो अभी तक लग जाना था. It is very likely, you will find, it is very likely that before 2021, which is the cut-off time of the legislative assembly, बंगाल उससे पहले इलेक्शंस होता है बंगाल में. Why? President's rule. It is very likely because if she goes on in this manner, it is very likely that there is a President's rule imposed. The law and order situation that is there in Bengal, this law and order situation, see Indira Gandhi, I'll give you an example. In 1960s, when Jyoti Basu for the first time he became the chief minister of the state, Jyoti Basu was from the left parties. Now he was from the left parties. 34 years of, Bengal has been under 34 years of misrule by the left parties. Rule तो नहीं है वहाँ पर, misrule ही है. I can say this because I belong to a state which borders Bengal, and I have seen what happens there. So under 34 years of misrule, Indira Gandhi once asked Jyoti Basu to take up a certain action which was against the interest of the state government. She called Jyoti Basu to the Prime Minister's secretariat and directed him to take up a certain function. Jyoti Basu said no. Indira Gandhi said fine. When he reached his car, that means from Prime Minister's office to the car, he got to know that okay, President's rule has been imposed in the state of West Bengal. President's rule was imposed in the state of West Bengal. Why? Because the Constitution directs that the executive power of the state shall be so exercised so as to not inhibit or in any way contradict the powers of the union executive. And the union executive has the power to give directions to the state. executive. And if you do not adhere to these directions, Article 365 says it amounts to breakdown of constitutional machinery. And accordingly, Article 356 says President's rule can be imposed. And this is what happens. Technically, it is called as, I'm telling you this idea. If you look at the violence that happened in the state of West Bengal during that elections, and what has happened in West Bengal currently. Now, what has happened in West Bengal currently, and it's not that the violence cannot happen in any state. It can happen anywhere. Whether it is, in Delhi also there had been problems. That was also the case in UP. That was also the case in other states along with West Bengal. But if you look at the role of the state government here, that means rather than the state government trying to somehow stop this violence, on one hand you see the chief minister of the state instigating that violence. That if this is not breakdown of constitutional machinery, nothing is. This is absolutely a breakdown of constitutional machinery. But right now, because we are in such a phase wherein, because Article 356, we are going to come to something called as an SR Bommai case, and the directions that were given by the Supreme Court in the SR Bommai case, the mechanism of directions are such that you will find that the center does not overuse Article 356 of the Constitution, and it does not misuse it. The SR Bommai case, the directions that were given under the SR Bommai case had an objective to ensure that there is no misuse of Article 356. If you remember, yesterday I wrote here 1994. Why? Because 1994 was the year wherein SR Bommai case, in the SR Bommai case, the Supreme Court came out with its directions of how to impose President's rule, or what will be the legitimate and illegitimate conditions and reasons to impose President's rule. And that is the reason why currently, after 1994, we live in a phase wherein the union government sparingly use Article 356 only when there is a case of political instability. So, if no government enjoys power, there is no government or coalition of government that is formed, in that case emergency, state emergency is imposed. Otherwise, if you look at what the Constitution prescribes for, the Constitution is very clear. Anything that amounts to breakdown of constitutional machinery, or if even the state executive does not adhere to the directions given by the union executive, that will also amount to the breakdown of constitutional machinery, and accordingly President's rule can be imposed in the state. This is the provision that is there. Now, when we talk about the state emergency, Article 356 of the Constitution does not just mention the mechanism. We have already discussed the mechanism. It also mentions the procedure to impose President's rule. It says once President's rule has been proclaimed by the President, in that case now the Parliament has to pass a resolution approving the President's rule within 2 months. Not within 1 month like the 30 days like the national emergency, within 2 months. And such a proclamation needs an approval by simple majority, not by special majority. Once it is approved, it does not continue. It does not continue only for 6 months. The maximum period that it can continue for is 3 years. No, maximum period that it can continue for is 3 years. However, after 1 year of proclamation of President's rule, it can continue beyond the period of 1 year if two conditions are satisfied. First, national emergency is in place in the whole of the territory of India or in that particular state. or if the election commission certifies that the current conditions are not conducive to hold free and fair elections. If these two conditions are satisfied, then state emergency can continue beyond a period of 1 year. Maximum that the constitution says is 3 years. It cannot continue beyond the period of 3 years. And once it has been approved within 2 months by the parliament, it can continue for a period of 6 months, and post the period of 6 months it has to be approved again by the parliament. These are the checks, the legislative checks that have been imposed on what you can say the proclamation of state emergency. What are the consequences of state emergency? The consequences of state emergency is the reason why we call it as President's rule. Why? Because the executive powers are now with the President, and the President can exercise it directly or through a particular office. The legislative powers are now with the Union Parliament, and the Union Parliament enjoys the power to legislate on any matter that is mentioned in the state list. Any matter that is mentioned in the state list. Thirdly, the President can issue ordinances. The President can even authorize expenditure from the consolidated fund of the state if the Parliament is not in session. Otherwise, the Parliament authorizes expenditure from the consolidated fund of the state. During state emergency, not only is the executive power concentrated with the President, even the legislative power and the financial power, because the President gets the authority to issue ordinances, and the Parliament gets the authority to spend the money that is there in the consolidated fund of India, consolidated fund of that state. So not only does the executive, but also the legislative and financial powers are concentrated with the Union. It is now with respect to, it is now the Union which enjoys such a power. Clear? In fact, this was the very provision which was used to amend Article 370 of the Constitution. Because if you see what Article 370 of the Constitution originally said, Article 370 of the Constitution originally said that any law that is made by the Union Parliament is not automatically extended to the state of Jammu and Kashmir. And for such a law to be extended to the state of Jammu and Kashmir, it requires the approval of the state government. So until as the state legislature and the state government approves it, it is not extended to the state of Jammu and Kashmir. However, Article 370, when it was actually amended, technically there was no government in the state, because the state was under President's rule. Which means, because Article 356 says that when a state is under President's rule, the executive and the legislative powers are now with whom? The Union. So when we say the state government, who becomes the state government during this period? The Union government. And who has to approve the extension of such laws? Not the state legislature, rather it is the Union legislature. This very provision was used to amend Article 370 of the Constitution. Clear? So if you look at the consequences, the manner in which the President is empowered, that is the reason why we call it as President's rule. Not only the President gets the executive powers, he also exercises some legislative powers and some financial powers. That is the reason why it is called as President's rule. Clear? Have you, see, though we are talking about Article 355 and Article 356, but the context here also demands that you know what is Article 256 and 257 and 365. Now, not only have we discussed Article 355 and 356, I have also discussed what is Article 256, Article 257 and Article 365 of the Constitution. And this is the context through which the executive, or the president's rule can be imposed. And this was the reason why it was misused. This was the reason, because the kind of powers that the union government gets because of this, that is the reason why this is being misused. This was being misused. Clear? Write down. Article 355. Article 355 imposes two specific duties on the union government. Two specific duties on the union government. First, to protect the states against external aggression, to protect the state against external aggression and internal disturbance, and second, to ensure that the government in the state is carried out, in accordance to the provisions of the Constitution. The mechanism of fulfillment of the second obligation is provided under Article 356, which states if the president is satisfied on the basis of the report of the governor, or otherwise that the government in a state cannot be carried, according to the provisions of the Constitution, the president can assume all the executive functions of the state. The president can assume all the executive functions of the state. The imposition of president's rule must be approved. The imposition of president's rule must be approved within 2 months. Of the imposition by both the houses of the parliament, separately by a simple majority. Once approved by both the houses, the president rule remains in force. For 6 months. And for further continuance. It has to be again approved by both the houses of the parliament. The president rule can continue for a period of more than 1 year. Only if 2 conditions are satisfied. First, there must be a national emergency. In operation either throughout the country or in any part of that state, in any part of that state, and the second condition, the Election Commission of India certifies that the conditions in the state is not conducive for holding free and fair elections. Precedent rule, no, next paragraph. Precedent rule can continue for a maximum period of 3 years, beyond which it cannot be extended. Consequences of precedence rule. First, all the executive powers and functions of the state are assumed by the president, which the president exercises on his own or a person or through a person appointed by him. Second, the president can declare that the parliament will make laws for the state. Third, the parliament can delegate law-making powers to the president on any subject in the state list. Fourth, the parliament can also authorize the president to spend money out of the consolidated fund of the state when the parliament is not in session. The fifth point, the president can also promulgate ordinances. For the state. These are the consequences. So, because of the kind of frequent use of Article 356, in 1994, in one of the cases in the Supreme Court called as the SR Bomai versus the Union of India 1994 case, the Supreme Court rationalized the use of Article 356. To a certain extent, it rationalized the use of Article 356. See, basically in the 1990s, post the demolition of Babri Masjid, 3 of the state governments were dismissed on the grounds that the government could not run in accordance to constitutional machinery. One of the previous chief ministers of, I think, Andhra Pradesh, SR Bomai, he challenged this in the court And in its challenge, the Supreme Court laid down what should be the mechanism and the manner in which Article 356 should be used. So we say that the Supreme Court because when we come through the decisions, you will find the Supreme Court rationalized the use. Why? Because it imposed certain checks. Because the Supreme Court imposed certain checks on how it is to be used, how Article 356 is to be used, when it should be used, and what is the manner of its usage. Not only that is, not only did the Supreme Court lay down certain guidelines, the Supreme Court also said that any such satisfaction of the President, that means why the President was satisfied that the Constitution, the administration cannot run in accordance to the constitutional machinery, it is under judicial review. It is under judicial review, which means the satisfaction of the President can be challenged in the court. The satisfaction of the President can be challenged in the court. And the Supreme Court said that if the court finds, the Supreme Court finds that the satisfaction of the President was on malified grounds, which means not in good faith, the Supreme Court will have the power to reinstate the Council of Ministers, and the Supreme Court will also have the power to reinstate the legislative assemblies if it has been dissolved. If it has been dissolved, because this was what used to happen. The Congress party, so in the state, if suppose any other party used to win elections, so they used to dismiss the Council of Ministers and dissolve the legislature. And that means that once the legislature is dissolved, so next elections are going to be conducted. Now, within 6 months, the Constitution prescribes the elections will be conducted. So during this particular 6-month period that they had, so the union government through the governor exercising control over administration ensures that, it ensures that it could create a condition so that people could vote for that political party. This was the political misuse that was going on. And the Supreme Court says that if it found that the reasons for declaring or imposing President's rule was malified, in that case it will enjoy the power to reinstate not only the Council of Ministers but also the dissolved legislature. So it will bring to life a legislature which has been dissolved by the governor. The Supreme Court in the S.R. Bommai case also declared that secularism is a basic structure of is a part of basic structure of the Constitution, and if secularism, if any particular state government violates the principle of secularism, in that case that will be considered as a breakdown of constitutional machinery. So in UP, when Kalyan Singh, he was the chief minister of UP and his government was dismissed, it was accused of violating, it was initially accused of violating secularism as the principle. And then, obviously the demolition happened. Mulayam Singh Yadav was the then chief minister, certain political events happened there. So when we talk about the Article 356, again in the S.R. Bommai case, it was held that secularism is a part of basic structure of the Constitution. Further, in the S.R. Bommai case, the Supreme Court also laid down, the Supreme Court also said that the report of the governor in which the governor mentions or invites the president to assume the executive functions of the state should be a speaking document, which means it should be such a document which should be able to point out to the fact as to why president's rule has been imposed. And the Supreme Court also said the reasons that are quoted in the document should be such that any rational person could conclude that there is a breakdown of constitutional machinery, and hence the president's rule should be imposed. The Supreme Court also laid down that a particular political party if they have lost elections in the Lok Sabha, that is not a ground to dismiss the political, the party if they had, now if they have a government in the state. So suppose Lok Sabha elections are going on, and like you see recently in month of March itself, Rajasthan, Madhya Pradesh and Chhattisgarh elections were held, and in all these three states, the BJP lost the elections and the Congress party was able to get the majority. What used to happen during the post the 1960s, now once the Lok Sabha elections were conducted, obviously the BJP gets majority, and in these states, specifically in these states, like if you look at Rajasthan, so in Rajasthan all the seats are won by BJP. All the seats were won by BJP. In the state of Madhya Pradesh, barring one seat, all the seats were won by BJP. That was also the case in Chhattisgarh. 3 seats out of 11, 3 seats were won by the Congress party and the others were won by the BJP. Now previously what used to happen, this was in itself considered as a ground to dismiss the government in the state. It was considered that because the state government has lost the confidence of the people, and that is the reason why they have voted for another political party in the union. So they have lost the confidence of the people, and therefore the state, the administration of the state cannot run in accordance to the constitutional machinery. It was assumed, and accordingly the government was dismissed. Similarly, the Supreme Court also said that the dismissal of Council of Ministers, and dissolution of the Legislative Assembly, it should not be simultaneously done. And first, if the Council of Ministers are dismissed, first the governor should wait till the 2-month period in which the resolution, this resolution has been passed by both the houses of the parliament. Only when it has been passed by both the houses of the parliament, then the Legislative Assembly should be dissolved, not before that. In the S.R. Bommai case, the Supreme Court also said the governor should not presume that the Council of Ministers have lost the majority in or confidence of the Legislative Assembly. The Supreme Court said the constitutional mechanism to decide this is the floor test. That is, in the Legislative Assembly, the governor can order the government to prove the confidence, but should not dismiss the government on an assumption that the government has lost the majority in the state. It should allow the government to prove its majority. If the government is not able to prove or get the confidence of the Legislative Assembly, they as it is go out of office. So through the S.R. Bommai case, the Supreme Court did what? It rationalized the use of Article 356 of the Constitution. Clear? So whenever you get a question on Article 356, don't shy away from writing some of these recommendations or some of these guidelines that were set by the Supreme Court in the S.R. Bommai case. Clear? Write down. S.R. Bommai case. S.R. Bommai versus the Union of India, 1994 case. 1994 case. First, the powers under Article 356, the powers under Article 356 is not an absolute power, rather it is conditional, subject to the provisions of the Constitution. Conditional, subject to the provisions of the Constitution. Provisions of the Constitution. Second, the governor should determine as to whether a council of ministers as to whether the Council of Minister enjoys the support of Legislative Assembly, enjoys the support of Legislative Assembly on the floor of the House, on the floor of the House. So not Governor's House, it means Legislative Assembly. Third, someone asked me one day, sir, which house? Obviously it is Legislative Assembly, not whose house. Third, the dismissal of the Council of Ministers, the dismissal of the Council of Ministers and the dissolution of Legislative Assembly, and the dissolution of Legislative Assembly should not be simultaneous, should not be simultaneous. The Legislative Assembly should not be dissolved. Legislative Assembly should not be dissolved unless the President's rule has been approved. Unless the President's rule has been approved by both the houses of the Parliament. Both the houses of the Parliament. Fourth, the material fact which forms the basis of satisfaction of the President can be looked into by the court, and the grounds must be one, which forces any reasonable person to the conclusion that the constitutional machinery has failed in the state. That the constitutional machinery has failed in the state. Next, if the grounds are found to be malified, the court can declare it to be unconstitutional. And reinstate the Council of Ministers, and revive the dissolved state legislative assembly, Next, the report of the governor should clearly lay down the grounds of failure of constitutional machinery, if an earlier existing council of ministers are defeated in the legislative assembly, then first an alternative government must be tried to be formed. Next, the state government should not be dismissed. If it has been defeated in the elections to the Lok Sabha, and the last point, secularism is the basic feature of the constitution. Secularism is the basic feature of the constitution, and if any state government violates the basic feature, if any state government violates the basic feature, it becomes a valid ground. It becomes a valid ground for imposition of precedence rule. For imposition of precedence rule. This is the decision of the S.R. Bommai case. One thing you have to add here, the 3-year limitation and 6 month. Now we had talked about procedure that maximum it can be for 3 years. Then we have also seen that after 1 year there are 2 additional conditions that needs to be satisfied, and we have also seen that once approved the state emergency continues for 6 months. All these 3 provisions have been added by the 44th constitutional amendment. Before the 44th constitutional amendment, this provision was not there. The 6 months approval, 1 year and the two grounds of satisfaction, and the maximum of 3 years period that is there, it has been introduced by the 44th constitutional amendment. Clear? Next, we come to the third emergency, that is financial emergency. Financial emergency under Article 360 of the Constitution. See, financial emergency what does Article 360 say? Article 360 simply says that it provides for the grounds, the manner, the reason and the consequences of financial emergency. The ground that has been mentioned is that if there is in existence a problem of financial stability, or the question has risen on the credit of India or any part of it. This is the ground that has been mentioned. So if there is financial instability or the credit of India is in question, or any part of it, not just whole of India, even if it is there for a state, if the credit of that particular state is in question and the president is satisfied on this, that this grounds exist, the president can proclaim financial emergency. The procedure to pass it is same, that is it has to be passed by both the houses of the parliament by a simple majority and within 2 months. However, once financial emergency is imposed, it continues and there is no need for it being passed or no need for it being approved every 6 months by the parliament. That need is not there. Now the question is, why is this the case? Why is it that it is for national emergency? Why is it for state emergency, but why not for financial emergency? The answer is very simple. If you look at this 6-month approval period or every 6-month approval idea that we have brought into our constitution, we have brought it into our constitution by the 44th constitutional amendment. And there was a political background to 44th constitutional amendment. That is, what happened in 1975 and how it was being misused. State emergency was being misused. So we imposed this idea that every 6 months it has to be approved by the state, by the parliament, both the houses of the parliament. In India, financial emergency has never been imposed. Because it was never imposed, so there was no ground for misuse of it. And because it has never been imposed, because it has never been misused, and that is the reason why Article 360 of the Constitution is in original form what it was enacted in the year 49 and implemented in 1950. When it was implemented, the same form, the same idea has been mentioned here. And today it says what? If the president is satisfied that the financial stability of India is in question, or credit of India or any part of India is in question, he can proclaim financial emergency. Such an emergency needs to be approved by both the houses of the parliament for within 2 months. Once it is approved, it continues. It continues for a period until unless the president does what? Until unless the president comes up with a proclamation to revoke national emergency, revoke financial emergency. Until unless financial emergency is not revoked by the president, it will continue. What is the consequence of it? The consequence of it can be seen in this manner. Because it is financial emergency, the consequences are more financial in nature. So what are the consequences? The consequences are that when we talk about division of financial powers between the center and the state, this division of financial powers between the center and the state ceases to exist. It is no more in effect. So it is now the union, and the union can direct the states to do anything with respect to what? With respect to better use of the money that it has. No autonomy to the states with respect to its financial powers. So the states, if they have to come out with certain policies and programs also, suppose some kind of what you can say welfare, socio-economic welfare program. So it will be implemented only if the union government approves it. If the union government does not approve it, it will not be implemented. It will not be implemented. Why? So that such policies program, laptop baant denge, TV baant denge, all these things are not there. Some kind of financial prudence is in existence. And there are no decisions are not taken by the states just on the basis of political viability, rather the economic viability of various policies and programs are also looked into. Second, it is during the financial emergency, only during the financial emergency when the union government can also what you can see, they can reduce the salaries and expenses of the officers working under the government of India or under the government of state, including the judges of the Supreme Court and High Court. Otherwise, the Constitution does not prescribe for this. If you look at the various constitutional positions that are there, whether we talk about Comptroller and Auditor General, or we talk about the judges of the High Court, judges of the Supreme Court, or the members of UPSC or such other commissions, committees and commissions that are formed under the Constitution, there is a limit to the executive influence on these bodies. And how is that limit imposed? That limit is imposed by this very provision that once they are appointed to such offices, their salaries and conditions of office are not altered to their disadvantage. बढ़ा सकते हो, घटा नहीं सकते हो. This is what it means. It cannot be altered to their disadvantage. So you can increase them, but you cannot decrease it, so that proper independence of this particular office is maintained. As it is, we have seen what are charged expenditures, and these kind of expenditures that are mentioned, they are generally charged on the consolidated fund of India. Why? To limit the executive influence on such bodies. However, when financial emergency is imposed, by the president, in that case, the salaries, conditions of office or pensions of even these individuals belonging to these offices can be altered to their disadvantage. So the president may say, you will have to work, but we will not give you salary for 6 months. It can be done when financial emergency is in place. Thirdly, the union government can also order, that means some money bills that are passed by the states. such money bills can be compulsorily, it might be compulsory for the governor to reserve such money bill for the consideration of the president. It might become compulsory. It might become compulsory for the government, for the governor to reserve the bill for the consideration of the president. And accordingly, the president or the union government can regulate the allowance or disallowances of the expenditure that is done by the states. So if you look at the primary consequence, that happens because of imposition of financial emergency is that the powers that are given, to the states, because we are a federation, so they have some exclusive powers. No, they have some powers that are given to them. These powers, a set of it is financial powers. The states are deprived of those powers during the financial emergency. And this deprivation of financial powers may have some executive and legislative consequences as well. Like under Article 201, all the money bills that are passed can be reserved for the consideration of the president. Obviously, that is a legislative consequence. Similarly, the executive power of the union can be used in such a manner that it can direct the state as to what are the activities you can do and what are the activities you cannot, where you can spend money and when you cannot. So the executive consequences are also there. Clear? So the financial emergency also, like the state emergency or like national emergency, it has some consequences. The consequences are against the autonomy of the states. The powers get concentrated with the union. In national and state emergency, all the powers, whether it is financial, executive or legislative powers, it get concentrated. In financial emergency, only the financial powers get concentrated with the union, but it has some executive and legislative consequences as well. Clear? This is what is financial emergency. See, we generally we never, we did not used to discuss this idea of financial emergency, but because there was a question asked, I think in 2018 mains examination, there was a question asked on financial emergency. That is the only reason why I am discussing it. So that if it ever gets repeated or you understand the consequences absolutely, that what are the financial consequences. Don't confuse, don't consider that because because state emergency is very similar to financial emergency, so that 6-month validity period is also applicable here. The constitution does not prescribe for it. It originally did not prescribe even for the state emergency, but it was only through a constitutional amendment that it was brought in, because financial emergency has never been imposed in India. It was once contemplated during the late 1980s because we were undergoing balance of payment crisis. So it was once considered, contemplated, but it was never imposed. It was never actually imposed. Clear? Write down. This is financial emergency. Under Article 360, if the president is satisfied that a situation, if the president is satisfied that a situation has arisen whereby the financial stability or credit of India, whereby the financial stability or credit of India or of any part of the territory is threatened, he may proclaim financial emergency. Underline financial stability or instability and credit of India. Next paragraph. Such a proclamation has to be passed by both the houses of the parliament within 2 months within 2 months by a simple majority, once passed, it continues until the proclamation is revoked by the president. Consequences. First, during the financial emergency, the executive authority of the union shall extend to giving directions to any state to observe financial propriety. The second point, it may also lead to reduction of salaries and allowances of all or any class of person serving under the state. Next, the president can issue directions for reduction of salaries and allowances of judges of the Supreme Court, and the High Court. Next point, money bill passed by the states has to be reserved for the consideration of the president after it has been passed by the state legislature. These are the consequences of financial emergency. Clear? Now, whenever we discuss the idea of center-state relations, though I will not be talking about it then, so I am mentioning it here itself, that though the constitution prescribes for a federal setup existence of provisions such as the office of the governor, we have already discussed that, we have already seen that, and also along with that, if we also see the existence of emergency provisions, this points out to the fact that India, though it may be a federation, but definitely it's not a federation which is of the kind that US is. In US, no such provisions are in existence. So India may not be, a federation that is of its own kind. That is of US's nature of that US is. India's federation is of its own kind. See, rather than criticizing this as an unfederal feature, which yes, if suppose the question comes, you can obviously write it as an unfederal feature also, but rather than criticizing it as an unfederal feature, according to me, if I have to put forward my opinion, in that case I will mention that this is not an unfederal feature. Why? Because obviously there is the Council of States, and the states, the Rajya Sabha is then, the Rajya Sabha is expressing its opinion while it is passing, it is approving any kind of emergency that has been proclaimed by the president. So because the state's opinion through the Rajya Sabha, the state's interest through the Rajya Sabha is protected, so the opinion of the states are considered, the interest of the states are considered. Secondly, when we look at the financial conditions of US and compare them to the financial conditions of India, now these positions may not be the same. The financial position of the states there and the financial position of the states in India, they are different. The manner in which we impose taxes, collect taxes and use taxes, it is very different from the manner in which they do it. So rather than considering it as an unfederal feature, what we can more appropriately see emergency provisions as is a feature which points out to the different nature of India's federation, or to more appropriately that optimized idea. We have optimized this provision to suit us. We have optimized this provision to suit us, and you can see that national emergency, there has been sparingly, it has been sparingly used, and once when national emergency was imposed due to wrong reasons, ठीक है, आज भी हम उसका गाना गाते हैं, ठीक है, we actually point it today also, we also consider it even today in a very recent speech that was made by the Prime Minister. It was in the month of June. So he was coincidentally बोलो या उन्होंने उसी दिन choose किया होगा, he was speaking on the same day on which emergency was imposed, on that day. So he pointed out to that. See, today also, 1975, which means it has been 45 years since we have actually that emergency provision was used. We still point it to that, which means that it is not considered to be something that is that will be used by political parties in the manner that it was ever used. कोई भी political party, even for the right reasons, they may not use it. आप देख सकते हो, we still suffer from problems such as Naxalism, and that is what the constitution says, internal armed rebellion. But we do not impose national emergency. We do not impose national emergency. If you look at the state of Kashmir, the region that is there, and the kind of separatism movement that is going on there, that goes on there, but we still have not imposed national emergency. We still have not imposed national emergency. So you can understand that when it comes to the kind of historical baggage that emergency has, it is very unlikely that it will ever be used for political gain. So how can we say it is an unfederal feature? A feature which is not evoked in our constitution that much. How can we consider it to be an unfederal feature? More appropriately, it can be described as a feature which suits us, suits the kind of federation that we are. It ensures that the union government uses it like a stick. That I can punish you. I have kept a stick here, so I can punish you, but I choose not to. I choose not to. That points out at two things. First, it is something that is an indigenous feature of our constitution. Second of all, it also points out to the historical tilt that we have. Yes, it is tilted in favor of union government. Our federation is tilted in the in union government, in the union, the powers that are there. But that does not mean we say in these provisions that are there, this is not federal. That is not the case. Clear? This is about the emergencies. This is where I end today. This is where I end today. 10 minutes heavy. But when we start our discussion tomorrow, I'm going to start with judiciary more likely. Otherwise, I take up another topic which I can complete in one day, that is public service commission. So I either take up public service commissions or I start with judiciary. Clear? So let us see. What I want you to do is, please go through Article 308 to Article 321 of the Constitution. Article 308 to Article 321 of the Constitution that are there. Please go through it. I am not going to discuss this very idea. If suppose I discuss this Public Service Commission or public services, I am not going to get into a lot of details here, because there are only some provisions which are important for us, for our examination perspective. So I am only going to deal with that. So I am going to talk about Article 312, which I have already talked about. I am going to talk about 311, 310, Article 315, 16, 17, but not in that length as it has been mentioned in your constitution. Only those part of it which is important for us. Please go through it so that we are able to complete this. Thank you.